Hey, my name's Josh Hunking. I'm an attorney in Willamette Valley, Oregon. Having a conversation today with Janine.
Janine, hi.
Hey, we're going to answer a couple of questions. These are picked by Janine, which is cool. You can pick whatever.
I thought they were interesting, and hopefully you guys find them interesting as well.
I agree. The question is...
So the question is...
Okay.
So I have them written down.
I can read, you know.
Yeah, but they're not in the same order. I just kind of...
Okay.
Wrote down how I felt it should go.
I trust you.
So the first question... okay. So what are the three branches of government and their roles?
The three branches of government in the United States are legislative, executive, and judicial.
Okay.
Their roles are to legislate, execute, and judge. That's what they do.
Okay, give us like an example of the task.
Okay, so if you look at the sub-definition of what is legislation, it's to create a law that applies to the future, right? I mean, so you just say the rule is you can't jump to the moon. Not allowed to jump to the moon. We'll put you in prison for the rest of your life if you jump to the moon. And the deliberative body of the legislature creates that rule that then applies to the future. The executive branch is what makes the rule real, because you could have a rule with no humans, and if there's nobody to enforce the rule, it doesn't matter that there's a rule, because there's nobody to enforce it. You've got to make it real in the real world, which means you need humans to enact the law, to execute the laws. And so, FBI, the state police in Oregon, they are there to execute the laws, to make them real. So you send a human who says, oh my gosh, Janine, you jumped to the moon. We're taking you to jail now. That's the way that works with the execution of the laws. Then the judicial judges, in the sense that they apply the facts to the law, right? Janine jumped, but she didn't make it to the moon, not to the veracity of, beyond a reasonable doubt standard. So that's what they do. They judge the application of the laws to the facts.
Are they interpreting? So what, they're all...
You have to. It's a.
So which one, the judiciary? Or?
Yes, it's a subsidiary responsibility in order, because the human language is fungible. And so as a result of that, you have to interpret, what does this mean if you're ever going to do anything real with it? So you have to apply a definition to a particular fact scenario to spit out a conclusion via an analysis.
So is their interpretation consistent across the board?
No.
Well, shouldn't it be?
In a perfect world, but humans aren't perfect.
So what interferes with that? Biases?
Sometimes it's biases. Sometimes really you're in a scenario where people have conceptions that underlie their perception of what something should or should not be, and that informs an interpretation of a rule. And I'll give you an example to make it a little bit more concrete. If you talk about... oh my goodness, I just lost it. Broken window theory. You know broken window theory? Broken window theory is... if you have one broken window in a neighborhood, you're more likely to get more broken windows or trash in the area, because if the place is already in disrepair, it seems okay to allow the place to be in disrepair. That theory is you can't allow trespassers, you can't allow loiterers, you can't allow small drug deals, because what you got to do is get rid of even the small stuff before it progresses into worse stuff. That informs some of the perspectives of judges in the 90s and 2000s in the way that they interpret the laws. So they will lean more towards one interpretation that results in, we got to stamp out these trespassers, whereas you get a different outcome if you don't believe in broken window theory, or if there are countervailing interests that are weighing more heavily on your mind. I think it was Judge Friendly, who took the canons of construction on rules and showed you can pick which canon you want to go by, and allowing the judge to pick which canon you want to go by creates the end result of you're picking the outcome. You pick the rules by which you interpret the law and apply it to this particular set of facts. You pick the outcome is what you did. And the judges know what they're doing. They understand, because they're smart. They can see to the end of the road. If I pick this rule and interpret this rule in this way, this is what the outcome is. They know what that is. They know what's going to happen.
What about the Roe versus Wade?
What about it?
The decision they made a while ago. Did they not see how that was going to turn out? Like, in maybe the later years, things wouldn't sit well, because didn't they overturn their decision? So what was the disconnect? Because if they're forecasting what would work in a later, I guess, culture, how come it didn't stick this time?
You're making a really good point, right? That what you're talking about is a decision made, I want to say 73 or something like that. And the Supreme Court basically construed the Constitution to create a result. They didn't have the benefit of what was going to happen over the next 50 years, which we have now. We know what happened over the next 50 years because it happened. And so because of that, their projection was that they would get outcome X or Y. And I don't know what was going through their heads when they were making that decision. The decision to overturn it is a little bit more easily analyzed because they did know what happened over those 50 years. They knew exactly what they were doing. They knew what they were doing. They were saying, look, we tried to create a rule whereby it was a constitutional right that you would have the ability to go and get an abortion. We then have had constant disputes over this for the 50 years that have come ever since then, including Planned Parenthood decision. I think there was O'Connor in the 90s, and many, many, many challenges to this. You know, the most recent one was Texas, whether you could, because Texas had created this system where you could file a civil lawsuit against a doctor for performing an abortion, and that would insulate it from challenge up at the Supreme Court level. They'd be forced to litigate the underlying case, which is really expensive. So the purpose was to design the law in a way that you could impose this burden on these doctors where they had to litigate these things, and it would just become not cost effective to then perform abortions because you're really spending all your money on litigation. So you're seeing these things again and again and again, and it's not as if we've sort of come to a conclusion where 100% of people agree that this is the right rule, or even 95% of people agree that this is the right rule. Not in the way where we have come to other collective agreements of like, I'm allowed to own stuff. I can own my shoes. That's something that people are just kind of cool with. You can't own people. That's a rule that we're all pretty much on board with at this point as permissible versus impermissible. Because it didn't quell the debate or anything like that, there's room for people to disagree and a decision to be made by 2022 Supreme Court justices. Do we let the democratic process do what it's going to do, or do we try to stick with this old rule that we created, which creates an interesting perspective on stare decisis, right? Which I think is an information gathering process. Do we and why look to a really, really old rule to inform what we should do? Or instead, do we look to the newest version of the rule for what we should do? And I'm perceiving a social change that the new rule is actually better because of the ways that we generate knowledge, right? Like we generate knowledge. If everybody's a farmer in the 1700s, or almost everybody's a farmer, the most valuable knowledge that's created relating to farming is probably the old guy in his anecdotal knowledge who's seen it for 30 seasons in the past, and he knows you put the corn here and you rotate your crops and you do that. That's your most valuable source of knowledge, right? Which then lends a hand to stare decisis of, well, this decision that was made is probably the right decision because we made it 50, 60 years ago. Or hundreds of years ago. So we should stick with that. As opposed to in the modern world, is the best way to farm going to be based on the anecdotal knowledge of a guy who has been farming for 40 years, or is it going to be based on research done by some company that says, look, we can do aqua agriculture now, and you can actually per square foot generate more tomatoes or onions if you do it this way. And because there's a recognition that the newer knowledge created in a different way through that more deliberate process creates better knowledge, it lends a hand against stare decisis and towards maybe we should go with the new rule. Maybe we should be thinking our way through what we're doing because we can get better results than if we just defer to, somebody who created a rule in a totally different time period. So it's an interesting how much do you pay attention to the old rule versus the new rule with stare decisis? But again, in 2022, those judges knew what they were doing. They knew that what's going to happen when we overturn this decision is it's going to go back to the states. Different states are going to make different policy choices. People are going to be able to get abortions in some places and not in others.
Well, this is interesting because I feel like the decision they made in '73, I feel like that was revolutionary. So, what was the thought process there in changing things so drastically? A complete 180 almost.
I wasn't alive in that time period, and I can't guarantee what was going through their heads. My guess, or my best guess, is going to be the differing or the change in the role of women in society in that time period. It's also, you've also got technological overtones where it's not as if in the year 800 abortions were a thing that you could go to a doctor and get. It wasn't a thing. So we've got the advent of birth control and, the ability to perform an abortion safely within a medical setting, which then sort of creates, every solution to a problem almost every time creates a new problem, right? It's a solution to one problem that you got birth control, and it creates a new problem of, okay, well, when and how can we use this? And to what degree should we use this? What's the best move for all of us, looking at, the relative benefits and detriments to the varied interests in the continuation of a pregnancy. That's, and then we argue it out.
That's an interesting conversation, but let's kind of go back. My fault, because I brought this up. But let's go back to the role of the legislative branch. So how long do you think, well, I guess it's not do you think, it's an actual fact, or usually there's like a time frame between, a policy being presented and then being put into law. How long do you think that goes?
You have to be more precise on which legislature you're talking about. If you're talking about like the Oregon legislature, at the beginning.
Let's do Oregon and then
the feds. I know less about the feds than I do about Oregon. In Oregon, you start the session, and then you read the rules, the proposed laws. Then you send them off to a committee. Then they go through a committee process. Then they go back to the floor of that chamber, votes on it. Then they kick it over to the other chamber, who sends it to a committee, who makes any revisions they're going to make, puts it to the floor. If it passes there, and there's any differences between the two, you need a committee of both the House and the Senate to be able to come together and say, well, this is a combined version that will work for both of us. Both of them repass the bill, send it over to the governor. Governor signs it. If they attach an emergency clause, then it goes into effect immediately. Otherwise, I think it's 90 days after passage, but it might be 90 days after the signature of the governor. It might also be 90 days after sine die, which is the close of the legislature, but I'm pretty sure that the answer is 90 days after the signature of the governor that it goes into effect. But they can put an emergency clause in it, and it just goes into effect immediately.
So it can be as little as like a couple of months, and then as most as a year, maybe?
Yeah, there's procedural rules. If you ever get the opportunity, go to the Oregon State Legislature and watch that guy read bills. It's an old-timey requirement that you've got to read the bill on the open floor. There's nobody listening to this guy reading the bill, because we can read. We just read them on our own when the time comes that you need to read the thing. That dude is very good at reading these bills out just so that it's formally read into the chamber. Again, it's a formality. Nobody's listening.
Where do these proposed laws come from? Can it be from the everyday Joe Schmo?
If you convince your legislator to enact it, yeah. Really? Yeah, they get proposed by legislators, those folks that get elected to the legislature. Okay. I think that in Oregon, at least, revenue bills have to start in the House of Representatives.
Okay. I think that was it then. We covered the executive branch, the judicial, and legislative. So,
which at the end state is very, very simple. Legislative, judicial, executive. What do? They execute, judge, and legislate. That's all that's happening.
It's in the word.
Yay! Okay. Till next time.
Till next time.